There's AustLII, ladies and gentlemen, the Australasian Legal Information Institute, which I hope many of you are familiar with using. But I thought I would start just by with some basic information about AustLII and its operations. We've been running for 20 years now, just over 20 years. Started back in 1995 by UNSW and UTS law faculties, and over the last almost 10 years joined by a charitable company, the AustLII Foundation Limited. All of the data on AustLII is free access, and as I say, they're surveillance free. So there are no logins. There's no tracking of individual users by companies serving up ads, and there are no value-added extras, no AustLII Premium or AustLII Professional or anything like that you have to pay for after you use the basic services. Everything on AustLII is value-added, premium and professional and free. We now have 728 Australian and New Zealand databases on AustLII, which over 20 years means we've been adding on average one new database at least every fortnight. It's about every 10 days for the last 20 years. So we now have pretty much all primary legislation, a lot of secondary legislation, the decisions of all courts and tribunals in the country, and those decisions now go back literally to 1788 in almost all jurisdictions, and with only a relatively small gap caused by copyright considerations. So AustLII is comprehensive of Australian and New Zealand law, both horizontally and vertically. The reason for this is that it's a largely automated operation. Most of AustLII's small staff of about 10 full-time people are skilled in programming, and we specialise in the sort of automated reception and processing and putting up on the web of the data using our own software. As a result of that scope, we are by some distance the dominant provider of electronic legal information in Australia. From our logs, we see that we get around 700,000 page accesses per day, and according to the Hitwise rating service, we have more accesses than all the commercial publishers together by quite a margin, and more accesses than all government websites together. But we don't have any core government funding or anything like that. The basis of AustLII's funding that comes to AustLII Foundation Limited is voluntary contributions by over 300 organisations, the details of which contributions are on the front page of AustLII's website. And we also compete for academic grants from the Australian Research Council and other organisations. The contribution side brings in approximately $1 million per year, has for the last 7 years averaged that, and the academic grant side accounts for about another $500,000 per year on average, but is up and down, of course, as grants tend to be. And basically we don't stand still. We're involved in continuous innovation, continuous development of not just new databases, but new technologies to deliver the content. Just this week we launched in Darwin the Northern Territory Law Handbook, with 70 collaborating authors on a new collaborative AustLII communities platform, so they can jointly keep up to date the sort of law for the layperson handbook for the Northern Territory. And we'll be putting a lot more services on that platform. We also released just a year ago the signed by AustLII versions of digitally signed decisions from all Australian courts to increase, their reliability and acceptability. So many things like that. So your emphasis today, I think, is supposed to be on client needs. And so that raises an interesting question of who are AustLII's clients? Well, we can't, as I've mentioned before, because of our policy of anonymous use, we can't track that all that carefully because most accesses come to us through ISPs, and that necessarily anonymises who's coming through. But free access to the general public is vital to AustLII, and that's our raison d'etre, that everyone should have access to basic legal information as part of a democratic society and the rule of law. But as it turns out, while we serve all sectors, 28% of our usage last year that we could identify from domain names comes from government, 24%, as you'd expect, from the educational sector, because AustLII is essential to law teaching these days. But 45% of our identifiable usage, the domain names that we can identify, comes from business, and that very largely from lawyers, both law firms and barristers. And the highest identifiable single legal practice in terms of usage has over 600,000 page accesses to AustLII per year. The highest law firm access from a firm that makes no contribution to AustLII's funding is over 220,000 page accesses per year. And there are many law firms out there who make usage of AustLII in the hundreds of thousands of accesses per year, but do not provide any funding assistance. So who does share the cost of free access? Because obviously, while we make it free to use for everyone, it's certainly not free to produce. So our largest client grouping in that sense is, as I've said, is the legal profession. The organisations of the legal profession, like the Law Society, bar associations, etc., contribute about 7.5% of that $1 million of core funding from contributors that AustLII relies on. There are only 74 law firms across the whole country, nationally, that contribute, and they contribute approximately 25% of that core $1 million funding. And we're extremely grateful for the support that we get from that small number of law firms. The rest, all of the other law firms in the country that make an enormous amount of use of AustLII, can only reasonably be described as free riders. So that's the current situation. In contrast, Australia's universities and university law schools last year contributed double that amount if you count both the contribution side and the contributions to academic funding and grant side, over $550,000 from Australia's law schools. So, but I mean, I'm pointing this out not just to point out the odd disparities in who funds free access, but because of its significance for the future of the legal profession. Now, it seems to me that the pressures, at least on sole practitioners, small firms, firms in remote areas, which means anywhere outside the CBD, are really inexorable these days. They're caught between at least three major sorts of increasing pressures. First is the multinational legal mega firms are soaking up all of the high fee work. It's very difficult for anyone except the mega firms to get a slice of that pie. Legal publishing is completely dominated by an international oligopoly. 3 major international publishers in Australia and no Australian legal publisher publishing legislation, case law, or what we used to call loose leaf services. And then thirdly, coming up the rear, of course, is the commoditisation of legal services, who compete by providing only very low and fixed cost services, and increasingly will. And many young lawyers will find that they have to work for those Ubers that are over the hill, taking a share of all professions in future. And there will not be any flexibility in the costs that they are forced to work for. It's a much tougher environment than when I practiced in law for a few years back in the 80s. Much tougher environment, I think, now for anyone who wants to stay independent of those pressures. Now, when they're wedged between such forces, how will small lawyers of various descriptions afford access to their essential tools, legal information, so that they can do their work, and quality legal information at that, so that they can compete on some reasonable basis? Well, they're not going to get any help from the international legal publishing oligopoly. It doesn't need to be worried about a very small market of the small practitioners of Australia. So that will not help. So it seems to me that one of the essential things that anyone who's interested in independent legal practice needs to be really worried about in future is how can they ensure that all key legal information is both free access and high quality. It's not much use having 10 different legislation sites out there and 150 different court sites for cases. That doesn't give you quality legal tools to work with. And how can lawyers in that situation find ways to share and pool their expertise without being exploited, and therefore have access to tools that capture expertise? These are really difficult issues. But one answer, one partial answer, is that well-funded and sustainable free access legal information services are an essential part of that future for any sort of independent legal practice. And so, to get back to what I was talking about before, at AustLII we see the profession's failure to fund quality free access is simply short-sighted in relation to their own long-term interests in survival. And while AustLII may survive, can survive quite reasonably doing what it does on the basis of the $1 million or so contributions per year that it receives, there's no question that better funding would provide better services, not just basic services. And on that final slide, I just sketched out a few examples of the sort of things that an organisation like AustLII can do if it had more funding available to it than it has at present. And they're the sorts of things that the legal profession will need to survive in the future. So I think we've got a couple of minutes for questions, and that's about it.
Thanks very much. Do you have any insight as to how lawyers can better use technology and online services to meet the challenges that you've outlined?
Well, I mean, they need to seriously study and get practice with the more sophisticated features of some of the services like AustLII. Like, you know, most users still don't know that you can go, you know, just go to a section of an Act on AustLII and click on the Note Up button and get all the cases and journal articles that are on the system that refer to that. And I mean, that's been around for 20 years. So, I mean, just getting to grips with these tools in a more sophisticated way is the starting point, because they're underused, they're underexploited.
Yeah, thank you. Questions from the panel?
Can I call you Graham, or would you
You
prefer
can
Professor?
indeed. No, I prefer Graham.
Graham. That facility you talked about is NoteUp's very useful, and by the way, AustLII's very much appreciated by the private practice, and especially sole practitioners, I've got to tell you. So thank you. But what about something like bailment? I want to make a inquiry. I've got an issue about bailment, and I want to look at the top 2 or 3 questions on bailment. There's no legislation.
Mm-hmm.
There's no case that'll, I don't need a case that's noted up. How can I search on bailment? Is that going to come?
It's back to basics. I mean, you need to think about synonyms: bailment, bailee, bailor. Put an or in between them. You can't put bail asterisk, or you'll get all sorts of things to do with bail, not bailment. It's not difficult. You have a sophisticated search engine that has all sorts of connectors and different ways to find things, and it's again, I think, a matter of just coming to grips with the facilities of the search engine. In many ways, our skills have been dumbed down by Google, because Google doesn't allow proximity searching or any of the other sophisticated features of search engines like AustLII search engine. It does wonderful things because of its scope, but sophisticated searching isn't one of them.
Thank you.
Graham, you mentioned pressures today compared to, you mentioned practicing in the 80s. And we've heard in your presentation 3 key pressures: the mega firms, legal publishers, and the commoditisation of law. And you've also identified 2 key client bases: the general public and their access to information, as well as lawyers having good quality access to information. Can I ask you about, how you see, if you could explain how each of those 2 client bases are drivers of change for AustLII, that is the general public, as opposed to the client base being the legal practitioners? How does AustLII cater for those 2 client groups?
Well, the Northern Territory Law Handbook that we've just launched this week is one of the key ways in which AustLII will be trying to cater to that general public need for legal information. All of the content of that handbook, which is written in a plain English fashion like law handbooks elsewhere, automatically is hypertext linked to any references to legislation, cases and the like that's on AustLII. So it's this sort of 2-tiered approach. Basic plain English legal information, but with sophisticated linking through to the underlying legal materials, so that those who want to pursue that further and have the ability to do so can do so. Now, with the legal profession, the other end of the spectrum, you'd point to things like AustLII's law site Citator, the only automated law citator that's found anywhere, and it's international because we have access to the content of all the other collaborating legal information institutes around the world, like Bailey in the UK. So we now have just on 5 million cases with full citation records, as I say, going back to 1788, in fact. And about 100,000 law journal articles that we now have on AustLII. So for the legal profession, a tool like LawSite is in some ways more sophisticated than you get from any of the commercial legal publishers. Not much interest to the general public, but we try to, it's a difficult balance, trying to get an interface that can serve both the general public and the legal profession, and tools that'll work at either end of the spectrum. But we just do our best with the funds we have available.